Welcome to Military Justice and the Law, presented to you by Bulani Tseu. In this episode, I'll be discussing the appointment of the Adjutant General and whether such an appointment is in any way problematic. Before the enactment of the Military Discipline Supplementary Measures Act 16 of 1999, the MDSMA, there was no separate division in the South African National Defence Force to deal with administration of military justice. However, since that enactment, there is now the Defence Legal Services Division. The primary function of the Defence Legal Services Division is to enhance the maintenance of military discipline through the military justice system. Soldiers who are involved in the administration of military justice are known as military law practitioners. There are, however, other soldiers in the legal division who are non-military law practitioners but assist with logistics and human resource aspects. Other soldiers serve as court orderlies and interpreters. The head of the legal division is known as the Adjutant General. The Adjutant General is not a judicial officer. He is the administrator and the manager of the legal division. Therefore, in my view, the appointment of the Adjutant General is supposed to be a big deal. The MDSMA provides for the appointment of the Adjutant General. It is the duty of the Minister of Defense and Military Veterans, the Minister, to appoint the Adjutant General. However, not everyone is eligible to be appointed as Adjutant General. There must be requirements that a candidate must meet before such a person can be appointed. For example, such a person must be an officer. In other words, he or she must have completed the officer formative course and duly commissioned by the President of the Republic of South Africa. Also, that person must be appropriately qualified. In the MDSMA, it is not stipulated what the term appropriately qualified entails. However, at the heart of it is that such an officer must have a legal qualification. Also, such an officer must either be admitted as an attorney or an advocate of the High Court of South Africa for a period of not less than 7 years. Military law practitioners who are neither admitted as attorneys or advocates are also eligible to be appointed if they have served as military law practitioners for 7 years or more. Another requirement is that such an officer must have been involved in the administration of criminal justice or military justice for a period of 7 years or more. So essentially, the plain reading of Section 27 disqualifies warrant officers, non-commissioned officers, candidate officers, and privates for being appointed as Adjutant General. Equally so, the plain reading of that provision disqualifies persons who have not served for 7 years and above in the administration of criminal justice or military justice. So the interpretation of statute makes it clear that the ordinary grammatical meaning of the text must be basically given effect to. So when one looks at this particular provision, Section 27 of the MDSMA, the canons of statutory interpretation make it clear that where the legislature expressly mention a particular requirement, that means that whatever is not mentioned there has been excluded. So, in my view, military law practitioners who have not served for 7 years or more in the administration of military justice or criminal justice but serve in other capacities, for example, as legal advisors to the chiefs of the arms of services or even the chief of the South African National Defence Force, such a person does not qualify to be an Adjutant General. So, when interpreting the legislation, the deviation from giving effect to the ordinary grammatical meaning will be when doing so leads to absurdity. And in my view, there's nothing absurd, or ambiguous with Section 27 of the MDSMA. Even if it was ambiguous, then we're to look at the purpose of the legislation itself. Section 2 of the MDSMA outlines the object of that particular legislation, which is to provide for the continued proper administration of military justice and to enhance the maintenance of military discipline. It is to establish military courts. It is also to ensure a fair military trial and access to the High Court of South Africa. So, essentially, the purpose is very clear. It must be linked as well to Rule 18 and Rule 20 of the MDSMA, which provide that the general principles of criminal law as applied in civilian courts apply in military courts. Equally so, the rules of evidence as applied in civilian criminal courts also apply in military courts. So the appointment of the Adjutant General is a statutory appointment. The minister has no discretion to waive those requirements. That appointment is not a cabal appointment. By a cabal appointment, I refer to appointments where promotions to higher posts and appointments to other offices are not done on merit or based on the competencies of the members, but merely done because of those people's loyalty to whoever has powers to effect such promotions or appointments. Moreover, another concerning issue with the appointment of the Adjutant General is that the MDSMA is silent on the procedure or the process to be followed by the minister when appointing the Adjutant General. In this way, the entire process is shrouded in secrecy. The door has been left ajar for the appointment of people, who are morally and ethically bankrupt with questionable characters. Because somebody can be installed as Adjutant General out of the blue. So basically, that is what it entails, the cabal appointment. Section 39(1) of the Constitution informs us that when interpreting legislation, we may consider foreign law by reason that other countries may have dealt with the challenges that are confronting our legal system. In this regard, I have looked at the manner in which the Canadians appoint their Judge Advocate General, which is the equivalent of our Adjutant General. Recently, Canadians appointed Colonel Holman as a Judge Advocate General. 6 months before that appointment, that post of Judge Advocate General was advertised, and people who met the requirements or who were eligible basically applied. The requirements are outlined in Section 9 of Canada's National Defence Act of 1985. And the process subsequent to the application is that members were interviewed, basically were subjected, to some scrutiny, which is a circumstance that does not happen when it comes to the appointment of the Adjutant General. In my view, South Africa can learn lessons from how Canada appoints the Judge Advocate General. So, in this episode, I've mentioned that the Adjutant General is appointed in terms of the MDSMA Section 27, and there are requirements that are set for that appointment. And it will be wrong for the Minister of Defense and Military Veterans to deviate from those requirements, because in doing so, that will be to cast doubt on the wisdom of the legislature. And such an approach will be constitutionally offensive in that it will undermine the doctrine of separation of powers. So in the interest of curiosity, it will be best for the listeners to basically do their own research to discover whether the Adjutant General, the past and the incumbent, met the requirements. Because if ever they do not meet the requirements, or the incumbent does not meet the requirements, that will mean that such an appointment was basically void ab initio from its inception, thus rendering such an Adjutant General an illegitimate Adjutant General. So basically, that is all that I wanted to register with regards to this aspect, that other countries, like Canada, for example, as I've mentioned, appoints their Judge Advocate General in a transparent manner, which is a circumstance that is foreign in our legal system. Therefore, it will be best then for South Africa to learn from the experiences of Canada in this connection. So I trust that you enjoyed this episode, and whoever has not subscribed, please subscribe. Following which, now from now on going forward, I'll be discussing the powers of the Adjutant General, as it is firmly entrenched that power corrupts. Absolute power corrupts absolutely. Thank you.